Okay.
Now, the purpose of this hearing was to consider any application which the defendant decided to make with a view to an amendment of the cessation of trading order to ensure that the defendant company remained viable. I said in the course of the hearing that I expected a sensible document to be produced which would have as its centre the minimum that would be required to keep the company viable, and I gave the example of salaries. Now, if we can look at the defendant's written submission, perhaps we should, before we do that, I should also say that it was contemplated that at this hearing there would be reconsideration of the undertaking, cross-undertaking in damages, which I required the claimant to give if the cessation of trading order was to persist beyond the 24 hours or so that I allowed for the taking of instructions. And we will come to that aspect of this hearing in due time. Now, the defendants have produced an attachment 2 which would appear to be in purported compliance with the liberty that they were given to ask the court to vary the cessation of trading order to the extent which was minimally necessary to maintain the company's viability. Now, Mr. Buderi, I'm bound to say that I find the approach that your side have adopted to this hearing thoroughly unsatisfactory. It is verging on being an abuse of the process of this court. I have a list of matters before me in attachment 2. There's no particularization given. It seems to be an exorbitant request going well beyond the 30 days, which are the relevant period of time, because the committee must give its ruling within 30 days under the decree. There's no evidence before the court. There's no signed witness statement verifying any of these matters. I am prepared to hear you briefly on each of these items to the point that I can understand them and can understand what they involved and why it can be said that they are the minimum necessary to keep the company viable. But I'm bound to say that that is an indulgence which I am granting to your side. In other circumstances, the court might well have taken the view that it's simply not going to entertain this application, given the way that it's been approached. Now, can you then please take each of these items and explain briefly what they go to and their justification, and we can then see where we go from there.
Yes, Your Honor. Starting at the beginning, the figures that we receive for the salaries and staff expenses from our client related to estimated expenses to the end of the year, and we've put in a bulk figure that related to staff salaries and expenses that given the 5 months remaining in the year, could be prorated to get.
Well, that could be, so that figure of 712,000 odd dirhams can be prorated to the end of the 30-day period. And of course, the whole matter must be reviewed again once we have the decision of the committee.
Yes.
Who knows then in which direction we are to go, and depending on what the decision is, you'll be at liberty to seek further orders. It may be that you won't need to do so.
Yes.
So I'm prepared to entertain an application that, in respect of salaries and staff expenses, that prorates that 712,365, and that can be done at a convenient moment with the use of a calculator. Now, what are general and administrative expenses?
General and administrative expenses relate to things, more or less mundane things like photocopying expenses, use of computers, telephone usage, maybe some local transportation. I think there's a rental expense as well in there. So things.
Rental for rental for what? For premises?
Yes. So the general and administrative expenses relate pretty much to the maintenance of the salary of the employees and people that are working on the project. So they're tied to those two items are actually similar in nature in that they've been estimated to the end of the year. They represent amounts that could be prorated as well, but they're tied to just the operations that are ongoing.
But have you been provided with any specific detail as to what it covers? You've told me photocopying and computers, telephone, and rental for premises. Do you have a breakdown of those matters?
I don't have it right now. I know that the defendant does have a breakdown, and they took these figures generally from their books. So their books are kept in accordance with general accounting practices. So I do assume that they have breakdowns of each of these items.
Well, you can understand why the court would have been assisted to see just what sums are attributable to what service. Photocopying and computers make complete sense, but what sums are to be attributable to them? The court needs some assistance as to that, and what we've got here is a rolled-up global figure. Now, I would imagine that the largest item in this line is the rental for the premises. Would that be correct?
Yes, I would think so.
Right. Well, we'll move on for a moment. Connection and authorities fees. What are these?
This is an amount which has been contested with the local municipality in terms of connection of water, air conditioning, I believe IT, telecommunications to the building. And these are somewhat complicated calculations to make because of the size of the building. And so there is an amount which has been claimed by local authorities of 6.6 million dirhams that has not been paid because the calculations on which it was based are being discussed and contested with them. So that's the current amount which is claimed, although the defendant believes that less than that figure would actually be payable.
Yes, thank you. Construction, what's that?
Construction is principally the second contractor that took over the works from Oger, and there is a balance due remaining payable to them. for completion of the works on the building. That's what that relates to. There are also some subcontractors as well. I think the term is snagging. There have been a lot of subcontractors who have been hired to perform snagging works in the building, and some of the snagging relates to that as well.
Well, we're talking about a period of 30 days from the 23rd of June. The petition was served, as I recall from the witness statement that was before the court last week, on the 23rd of June. I haven't brought my calendar or diary with me. Can someone help? What date in July is it that is the end of the 30-day period from the 23rd of June?
I think it would actually be sometime in August because it's working days.
It's working days, is it?
It is. I
Yes.
know the claimant made a calculation of that. I think it was the 11th of August. Is that not correct?
To the 11th of August.
Assuming that there's no extension of that date because of whatever reason that the committee might decide.
Well, on its face, it's under an absolute obligation to produce the decision in 30 days. But of course, whether there are any particular rules of construing these decrees or not, I don't know. The prorating is more than 30 days. Can someone tell me the number of days between the 23rd of June and the 11th of August?
It's 7 calendar weeks between those 2 days.
7 weeks. Thank you very much, Lima. Now, as to these construction costs, no doubt there may have been demands for payment certificates issued and so on. But as I understand it, there are no proceedings on foot by these contractors seeking legal remedies in respect to these sums due.
No, with respect to the construction costs, I don't believe there are any proceedings. There is a proceeding that's begun with regard to the consultants, which is the next.
Okay, we'll come on to that. But
As a point of clarification, Mr. Pateri might want to clarify whether by proceedings is excluding arbitrations.
The only proceeding I'm aware of is a proceeding that was begun by a consulting engineer who was to assist in the defense of the case against Oger, who was subsequently terminated for lack of performance, says the defendant, and that has led to this proceeding that is not an arbitration proceeding. It's a court proceeding. In fact, it's been filed in the DIFC courts.
But has a defense been entered justifying the termination of the...
Well, the case actually was brought in the Dubai courts. It was dismissed in the Dubai courts recently. And a claim was then brought in the DIFC courts. It was very, very recently, an acknowledgement of service was filed, and the defense is due, I believe, the middle or end of next week.
But it will be defended?
Yes.
Yeah. Right. Thank you very much. So, is the nearly 6 million dirham along the line of the consultant's line, is that this claim by the consulting engineer doesn't involve other claims from other consultants?
No.
No. Right, thank you very much. Service charge payments.
Service charge payments are payments which the defendant, as it is still an owner of certain limited number of units in the building, is required to make with respect to service charges that are assessed against all unit holders in the building. So that is a payment which is due for maintenance of the building as an owner. All unit holders, apartment, office, whatever they might be, are assessed a service charge. And so this is the amount that relates to that.
Now, are these, they'll be paid periodically?
Yes.
Is it a monthly charge, an annual charge?
I believe it's a quarterly charge, but I would have to verify that.
And is the sum here an accumulation of outstanding charges, or is this sum simply in respect of current bills?
This is an accumulation of amounts owed.
Can you tell me over what period of time?
I'm afraid I don't have that information here.
Thank you. Owners Association bank balance transfer. Can you help me with that?
Yes. For a period of time up to and including about the first quarter of this year, the service charge payments, which we've just discussed in the above line, were paid to an account held by Daman in trust, essentially for the benefit of the building maintenance company or management company, which had not yet been able to establish its own bank accounts, and or at least was not in a position to receive the payments that were being made throughout the building. So all those payments were channeled through Daman Recap.
Yes.
Daman Recap didn't consider it that those were its monies. Those were service charge payments received from numerous tenants, and then they would be transferred to Place Management Holding, I believe is the name of the management company. So, and those had been notified, I think periodically to the claimant, if I'm not mistaken, because transfers had been requested and had been made, and under the freezing order, since the monies were held in a bank account of Daman Recap, they needed to notify the claimant of the transfers, even though they didn't consider it to be their money. So those transfers were being made. Recently, the structure of those payments has been changed. The payments now go directly to this company, but there was a residual amount held in a bank account.
Now, is this sum ring-fenced so that in effect it is available for payment to the management company when the management company is in a position to receive it?
Yes, yes. And I think the management company is in a position now to receive it. And it would be the last, there would be no, this item would not appear again because it was just a residual amount which was being held in an account of Daman Recap that had not yet been transferred over when the cessation of trading order came up.
Now, on the basis that this is ring-fenced, and in effect it's in a specific account, possibly subject to trust obligations in favor of the management company, can I take it that the management company have not issued proceedings in respect of this payment? No. For the moment, they feel sufficiently secured by the fact that it's held in this specific account.
I haven't spoken to them, so I don't know what their state of mind is, but I don't believe proceedings have been started. And that account is exclusively for that purpose.
Yes.
It's not an account which is holding monies due to other places.
I understand. Professional fees?
Professional fees relates to essentially technical consultants, technical engineers, and others who have been working on the project and who have amounts owed. I believe there's, for example, an amount owed to an automated parking garage in the building, and this is quite complicated technically. So there's a technical consultant that had to resolve certain problems related to that. That's one example, but I think there are probably half a dozen consultants or more that have been working on various technical issues in the building, and that's what those professional fees relate to. And those are accumulated.
Yes. Yeah. Can I take it that there will be a loan account between the company and those who have been providing financing pro tem?
Yes, there is an account.
And one would imagine that the main source of those loans would be the shareholders, Daman shareholders.
No, the main source of those loans has been bank. There's bank financing, which we'll get to in a minute, but there's still an amount owed to a bank which has a security interest over the building.
So there are no shareholders' loans?
There are shareholders, but the main source, I think the amount of equity that was invested by the shareholders is much smaller than the amount of the bank loan.
And I'm thinking, I'm not thinking of simply equity finance. The money which went into the company on the original subscription for those shares. What I have in mind is loans which are advanced by the shareholders to the company in order to provide it with working capital.
No, to my knowledge, no such loans are in existence. The structure of the project was not set up that way.
So the whole thing is founded on bank financing?
No, it's founded on three sources of revenue, which would be the shareholders who did invest significant amount of money, the bank financing,
yeah,
and the sales of units in the building, which probably like a lot of projects in Dubai, began with payments that were made while
off the plan.
Yeah, off the plan, which was essentially a hole in the ground, and then payments came in as the building went up. Yeah. So those were the three main sources. Those are the three only, as far as only the three sources of financing.
Yes, I see. Thank you. Legal fees. Now, what's happening under the Morava injunction with respect to legal fees? I haven't gone back to look at it. Normally, of course, there is liberty subject to reasonableness for assets to be used for legal fees. Is that
that was not? No, the freezing order did not include an exception for legal fees. As far as I recall, we treated legal fees and the payment of legal fees as a normal item subject to the freezing order and have notified the...
I see. Yes, it's been subject to notification.
Yes, it has been.
Right. Now, given that that mechanism for payment of the fees, presumably the fees have been paid periodically.
Yes.
Now this is quite a large sum that's accumulated here, 2.3 dirhams, legal fees. How long has that been outstanding?
I would say close to 5-6 months, and what that would cover, just so Your Honor has a sense of the different legal, the role of lawyers in this case. There's been the proceedings in Dubai. There have been the participation of solicitors, ourselves, and counsel with respect to the freezing order, some of which was done towards the very end of last year, and part of that amount is reflected in here. There were proceedings related to the insolvency matter, which was before Your Honor, and there's been activity before and in relation to the Decree 19. So there have been various legal proceedings that have involved different lawyers. There have been special counsel that came before you, Mr. Allison, on the insolvency matter. There was Mr. McGraw, who came before Justice Steele on and Justice Omer on the matter of the freezing order, ourselves as well, and two law firms in Dubai which have been working on the Dubai proceedings and the ramifications of the decree.
Yes. For a period of 7 weeks, can I take it that those who are owed these legal fees are unlikely to take summary proceedings for their recovery, and are equally unlikely to terminate the retainer?
I can't speak. I can speak for ourselves. We would be unlikely to do that. I can't speak for counsel who would be asked to be involved.
Yes.
I would probably say they would not fit in that category. The lawyers in Dubai, I would find doubtful that they would bring proceedings or terminate the engagement.
During the 7-week period. Yes. All right, thank you. We may come back to some of these things. Legal settlements.
Legal settlements is a one-off item which related to a disgruntled purchaser in the building who, because of the delay in delivering the project, had brought a case or threatened to bring a case. I can't remember if it was actually filed. And the company settled with him for this amount.
But it remains unpaid.
It remained unpaid.
And what's the claimant doing in respect of this lack of payment?
I don't believe he's been heard of since the settlement was reached, and so it's a little bit unclear why that is the case.
Yep.
That was reached.
Thank you. Thanks. Next line, the bank loan and interest. So these are the borrowings that the company has made. What, over the life of the project? Is that it?
This is the amounts that were due under this loan are overdue, I should say. They're accumulating interest. This is the residual amount. I think the amount of the loan, the claimant would know this because they introduced testimony about this loan in the arbitration. But the amount may have been upwards of 500 million dirhams, I believe, and it's been repaid. This figure represents, it's about mixed, half and half is principal and interest. And so that is the residual amount owed on that.
And is this secured lending?
Yes. It's secured with the bank, which is Emirates NBD, has a caveat over the entire building. And so they're holding that form of security. And prior to the cessation of trading order, a resolution was reached between the defendant and the bank under which certain units that were still unsold in the building would be sold to the bank. The monies would be paid from the bank to the defendant, and those monies would be virtually identical to the amount of the outstandings. That money would then be paid back to the bank to satisfy its loan. That debt would be expunged from the company's books, and then that would be the end of the security that the bank, or the liens that the bank had over the building, which had created some complications with respect to certain purchasers who wanted to receive title and had not been able to do it because of the bank's senior position. We submitted that transaction for approval, freezing order. It was not. It was met with concern by the claimant. It was not approved, and then events transpired. The cessation of trading order came in, so the whole thing has fallen away.
Yeah. Yeah. Can I take it that the bank hasn't served a notice of default? It's not suggesting that you're now in a situation where there's an accelerated balance that must be paid within 30 days or whatever it is.
I know that the bank has, of course, expressed consternation about not being paid back, and there are numerous letters of threats or complaints that have been made to the defendant. I don't believe that any acceleration rights have been activated so that they could actually take hold of these items. And we thought, the transaction that was on the table, we thought was quite attractive because the bank, we felt, was in a position where they were willing to pay what appeared to be slightly higher than fair market value for the units because they felt that this was a good way to complete this matter with least amount of complications. But, but I don't believe they've formally activated any mechanisms for accelerating the loan under the agreement that they have.
There's been no crystallization of any charge over the security arrangements. It's there, available to the bank, but so far,
it's just accumulated and charging interest as they go along.
Right, thank you very much. And then, lastly, other payable amounts, including management fees. Can we have some detail on that?
Yes, these amounts are managed. The single biggest part of this is management fees that are owed to the project manager of the building, who was Daman Investments. So that's under an agreement which exists between Daman Recap and Daman Investments. Daman Investments had entered into to structure this transaction, to arrange the financing, to do other things that you have to do to actually develop a project of this nature. There was a management contract, and that management contract still has an amount of, the lion's share of this is about $23 million.
And it's an associated company, is it, within the Daman group, if I can call it?
Well, I think there's always been a little confusion about that. They share a name, Daman Recap and Daman Real Estate Capital Partners and Daman Investments. And Daman Investments established Daman Recap as an SPV for this project, but Daman Investments is a 5% shareholder of the company. So it like a lot of project companies that put a deal together like this, they took equity in the project themselves to have some part of it. But then investors make up the lion's share of the capital. Some other parties related to Daman are also investors in the company, but by and large, the majority of the shareholders are unrelated third parties.
Right. Excuse me. Now, how long has this item been outstanding?
I think most of this has to do with calculations that were to be made on the profitability or not of the project, of certain other parameters that are set out in the contract that were to be assessed towards the end of the project. So I I would have to revert to the client for more detail on that, I'm afraid, Your Honor. I don't know how long it would be said that they were actually outstanding.
Yes.
I have a feeling quite a long time, but I need to check.
All right. Thank you. Now, Mr. Brannigan, I'm going to hear you briefly. You've heard what I had to say at the beginning of the hearing.
Yes.
About the approach that has been adopted to making this application essentially on a liberty to apply. And I think it's unnecessary to hear any general criticisms that you have to make about the way that this material has been presented. I only say that for the sake of the economy of time.
I understand.
I have your written submissions. So I would like you to concentrate on the real nuts and bolts of what we've heard from Mr. Buderi.
Certainly. In relation to salaries and staff expenses, we have done the calculation, and a pro rata of the unquoted figure put forward leaves one with 118,727 dirhams. Okay, that is taking it and dividing the sum by 6. There's a more complicated way of doing it, of working out the precise daily rate, which leaves you with 22.8% of the figure. But I think the point is this, my Lord, that if you're minded to allow them, as we set out in our skeleton, if you're minded to allow them to pay salaries and so on, that looks to be the figure. For general and administrative expenses, it surprises us that it is said that the largest bit of this is rental for premises. We have no idea what those premises are, given that Daman, in fact, owns substantial premises. And it might be useful to have at least some indication of what these premises are and what rent's being paid for them. Because as we sit here now, we have no idea what they're talking about. In relation to most of the rest of this, my Lord, what you've managed to establish, if I may say with respect with your questions, is this. This isn't an indication of what has to be paid in the next month or even the next 6 months at all. This is an indication of the fact that Daman just doesn't pay people. And so it is left in a situation where it hasn't paid its connection and authorities fees, but now wants carte blanche to do what it likes with that going forward. It hasn't paid, not only has it not paid us for the works we did, notwithstanding our arbitration award, but it hasn't paid the people that came after us to the tune of nearly 50 million dirhams. The building that the people who come after us built, or finished off more accurately, was completed in 2015.
Yeah.
The suggestion that this sum, which Daman have refused to pay to date, will need to be paid over the next month, or even over the next 4 or 5 months, it is one that simply cannot be argued with a straight face. If it did have to be paid over the next month, there is no indication whatever of any evidence in support of that notion. And presumably Daman has good reasons for not paying it, or it would have paid it. And certainly any suggestion that that would be somehow prorated doesn't make any sense at all with respect. Because it is either a sum that is due or is not. It's not going to be...
Sorry, which line are we on now? Or is it a more general...
I was talking about the construction line.
The construction line,
yes.
Yeah.
If it goes back up to put some flesh in it, the connection and authorities fees, you and I, my Lord, have no idea of how long that figure has built up, or for what length of time it is said those connection and authorities fees relate to. But what I do understand from what you've just been told is that this isn't a future, under connection and authorities fees, this isn't a future liability that will fall due. This is a sum of money that Daman just have not paid for an unspecified period of time, but which it now contends it will have to pay over the next month, as I understand the submission. but with no support for that proposition at all.
Yeah.
So, going down then, construction is the one I've just been speaking
Yes,
about.
you have, yeah.
Consultants. I wasn't quite sure I followed what the consultants relates to, but as best I understand...
Well, it was a consulting engineer who was engaged to provide engineering services, and his engagement was terminated, and he's bringing proceedings for sums which he says are due, whether for work done or for loss of opportunity to have earned fees over the period of the consultancy. And proceedings in the Dubai courts went nowhere. He's begun proceedings in the DIFC, and these proceedings are going to be defended.
Well, in a way I need to say no more about that, because it certainly looks as if that is a sum which the other side do not believe is even due, let alone that they should have permission to pay. And certainly it is not a sum which, if they do not pay within the next month, will cause any prejudice, so will prevent them from trading.
Yes?
It's service charge payments, I probably need to say little else about. It looks like this is a sum of money which is already protected. We are told it is held in something like a trust account, and so there needs to be no transfers made about that. Onus association bank transfer. Sorry, that's the one I've just been speaking about, the one that's held in trust.
That's the one that's held in trust. The service charge payments are...
An accumulation, again,
Yes.
over a period of time. You haven't been told what that period of time has been. You haven't been told why Daman haven't chosen not to pay those service charge payments over that accumulated period of time. It will now need to do so over the next month.
Yes, go on.
Professional fees of 739. Again, as I understand what's being said, these are historic sums which have been built up, which again Daman simply have not paid. There has been no proper explanation given to you at all, my lord, as to why suddenly in the next month you now need to be paid. Legal fees of 2.3 million going forward. I was surprised to hear that that will include sums owed to council and so on. Because if you look at attachment 3, attachment 3, my lord, is our sums for which we have been asked, which have been notified to us, are being paid. Whilst attachment 3 is not numbered, you can see at the bottom of the first page where you can see the total amount in dirham of 4.7 million.
Yes.
You can see that Curtis Mannett owed you dispute legal expenses just over $1 million US. We've always understood that to be a sum that we were asked to agree could be paid under the freezing injunction in relation to previous legal expenses, and we had always understood that that had been done. If you carry on forward through 1 page, 2 page, 3 pages, 4 pages, you come to a total amount in dirhams of 4.444 million.
Yes.
You will see, my lord, entries there, which again, this reflects sums which we have been told are being paid and which have been notified to us are being paid. You will see there the sum which we are told was being paid to Mr. McGraw, QC, who was my opponent in the freezing injunction, and Mr. Peters, who I understand to be his junior, in the sum of £170,000 and £40,000. And we've been told, by means of notification, these are sums which are being paid.
Well, what we don't know is the extent, if any, that there's any overlap between the line in attachment 2 and these sums which have been paid.
Well, we don't, because we've had no proper explanation for it whatsoever. What I can tell your lordship is that the freezing injunction was a 2-day hearing. for which Mr McGrath as Jr. have been paid £210,000, it would seem on the face of it likely that that is the sum total of work done in relation to a 2-day freezing injunction.
Yes. Well, there's been a certain amount of legal activity since then.
But none to which I'm aware Mr McGrath has been involved.
I'd be happy to provide an explanation.
Yeah, by all means, in a moment. Yeah.
So, the point which your Lordship makes is well taken. All I can do is point to the information we have, point out to your Lordship that the line items we have don't provide any proper basis at all for suggesting that these are legal fees which will even fall due, or let alone have to be paid over the next month or so until we get into August the 9th. Legal settlements, my Lord, I probably need to say little about in a situation where it appears this is again a historical sum, which has been outstanding for some time, which Daman simply haven't paid, and which there looks to be no basis at all to suggest they will have to pay over the next month. Bank loan and interest and other payable amounts, including management fees. Well, Lord, if these are sums which are fall due, then so be it. We are due £1 billion dirhams. This is all a matter which the liquidator in due course will have to deal with. But what we do know is that there is no proper basis at all to suggest that unless these are paid within the next month or so leading into August the 9th, that Daman will go under.
Yes.
So what we would propose, my Lord, is that if your Lordship is minded to approach this in the way you indicated at the last hearing, the only relevant line entry here really is salaries and staff expenses. One could see that some element of general and administrative expenses, but it is impossible to know how much, might also fall into the category of sums which in fact may well need to be paid between now and the 9th of August to enable this company to keep going. But none of the rest, my respectful submission, fall into that category. And whilst I don't make a general criticism, it is disappointing that your Lordship has had to conduct the inquiry you have this morning in order to establish that.
Yes, well, thank you very much. Yes, Mr. Baderi. Anything by way of reply?
Yes. I won't necessarily go blow by blow, but I think maybe there are two or three points that should be made. First, let's look at the matter of legal fees. Yes, there have been legal fees paid, requested and paid, including for Mr. McGrath and Mr. Allison, but each of them was involved in more than one proceeding. Mr. McGraw's first involvement in the case was on the heels of the freezing order, which was received ex parte by the claimant, and one of the first matters he had to deal with was the fact that the freezing order that was given to the court by the claimant was represented as having been a conventional freezing order in the usual terms, but it did not include an exception for ordinary and proper business expenses, as we then learned after it had been issued. So the first matter that Mr. McGrath had to deal with was correcting the situation in which the freezing order, which Justice Chadwick was assured was in the usual terms, was not actually in the usual terms. That had to be corrected. Then was involved in the first hearing, two hearings in divide. The first hearing having to do with the freezing order, and then later the appeal at which he also presented the case. So certain payments have been made to him, certain payments have been made to Mr. Allison as well. Mr. Allison was also involved in two proceedings, one before Justice Steele and the other before Your Honor.
Yes.
And part of the involvement of both of those gentlemen has been paid, and part of it is not.
Part of it not. Can you help me with this, a small detail? What was the appeal that Mr. McGrath was instructed in? I know there was a hearing before Justice Steele because Justice Chadwick had made a short interim order with a return date, and then the matter was fought out, so to speak. And there was an appeal, was there, from that?
There was a proceeding before Justice Steele as to the recognition and enforcement request of the award, and for the continuation of the freezing order. The decision.
Was there an oral hearing, or was that a written application?
It was an oral hearing in Dubai.
It was the same hearing. There was one hearing at which the continuation of the freezing order and the enforcement of the arbitration was considered at the same time.
Yes, I'm just wondering where the appeal level comes in.
The order of Justice Steele recognized rejected, in his view, the viability of most of the arguments that were being presented in Dubai.
Yes. He held the one point went to the jurisdiction of the tribunal, as to whether or not the tribunal were correct to construe the decree retroactively.
Correct.
I remember that. That was in his judgment. There was then an application that was made, a slightly unusual application in my experience, not simply for leave to appeal, for permission to appeal, but was an application made for the setting aside of various orders because justice so required. And that was something which the Chief Justice dealt with shortly before I gave judgment. I actually gave judgment. There was a hearing before Justice Omar, wasn't there?
Yes. Let me clarify that. The hearing, or the matter before the Chief Justice came later. Prior to that, the matter of the appeal of Justice Steele's decision
it went before Justice Omar.
It went before Justice
And he
Omar.
refused permission to appeal.
He refused permission to appeal.
Yes.
When, and based on the decision of the Court of First Instance in Dubai dismissing the case for lack of its jurisdiction to hear it, which is why we say the decision of Justice Omar was based on the confusion as to jurisdiction, which is now before the committee. The Justice Omar was asked quite a few weeks before that decision came out to rule one way or the other on the request to appeal Justice Steele's decision. He held a hearing at which Mr. McGraw appeared and ultimately sat on his decision for a couple of weeks, as I recall, and issued his decision after the Court of First Instance had said they don't have jurisdiction to hear this annulment case.
Yeah.
Then, and only then, did he issue his dismissal of our request to appeal.
Yeah.
So that was the appeal.
Okay.
And then the matter of the reconsideration came
After that, it was it was Justice Omar's decision that prompted the further application for a reconsideration and so on. Yes, so thank you. I remember now.
I think
yes, do go on.
I think the only other point I'd like to make is that most of these categories have actually reflected payments that have been made in the course of the 6 months or so while the freezing order was in effect.
Yes.
So, even on construction, as I said, it also includes amounts for DLPs, which are basically snagging items.
Yes.
Those have been routinely presented to the other side in 48-hour requests.
Yep.
And subsequently paid. Transfers of the service charge payments have been routinely requested. Legal fees have been requested. Professional fees have been requested and paid routinely. So Your Honor asked a very valid question, which I don't have a clear answer to, which is what time period each one of these relate to. But, and I would need to check that. But most of them are categories of payments which have been made.